Kalikumutima and Company Advocates, translating visions into reality.
Because if I'm jointly owning my land with my children, 5 children, I die, the land is for the children. The children die first, the land is mine. So really, what is it? Yes, and I don't need to go to court. I don't need to go to court for anything, okay? Because of the principle of survivorship, that when one dies, joint ownership, the property devolves to those who are surviving. It is the automatic operation of the law.
Some minutes to begin. I was supposed to begin at 7, but we wanted to give you time to prepare for this discussion and to allow others to join so that they don't miss out. So this profession is going to dwell on the succession law. We are going to dwell on estate administration, expiration of grants of probate, auditors of administration, what to do about them, and if you're dealing in a set of deceased person, what should you look out for? So joining me today is Mr. Henry Kuloba Wesaka. Mr. Henry is the Second Administrator General and the head of litigation in the Administrator General's office. We will give him 2 minutes to first say hi to the listeners. He will give us a brief introduction of what he does, what makes him tick, and we kickstart a question. Mr. Henry, over to you.
Thank you, Alfred, and good evening to the listeners. Yes, I am Henry Kuloba, and an Assistant Administrator General in the Office of the Administrator General. The Office of Administrator General, of course, is a statutory body and has also a constitutional mandate, which is basically ensuring effective and efficient administration of estates of deceased persons, missing persons, and persons with mental illness. So it is an office that has its head office at Georgian House, George Street, but also with a number of regional offices all over the country. So our services can be accessed, yes, at the head office here in Kampala, but also at a regional level. We have offices. So basically, our work is administration of estates of deceased persons, and where we don't administer the estate, we vet applicants who want to administer the estate, and we issue them with what they call the certificate of no objection. So that is where the Administrator General is not going to administer the estate. So the family itself sits and appoints people who are going to administer that estate. Management of estates of missing persons and persons with mental illness. So in brief, that is what the Office of Administrator General does, and it is important that the general public knows our services, because death is part of life, and all of us in one way or another will need the services of Administrator General. So thank you very much for the opportunity, Alfred and team, for me to come and interact with the general public on this very topical issue under discussion.
Yeah, thank you, Mr. Henry, for that brief introduction. Also joining me today on this amazing discussion is Mr. Kalikumutima Deo. Mr. Kalikumutima Deo is a Christian lawyer. He's the chief executive partner of Kalikumutima and Company Advocates. He's a Rotarian. He has very many titles to his name. I don't want to, I may forget some of them. So to avoid forgetting some of them, I will invite him to say hello to the audience in 2 or 3 minutes before we go deep into the conversation. Mr. Deo.
Thank you so much, Alfred. To our viewers and listeners, habari, wherever you are, good morning, good night, good afternoon, good evening. It's a pleasure having you here. I have been introduced, but allow me to emphasize that Kalikumutima and Company Advocates is a Christian law firm, and yes, I'm a humanitarian. So whatever we are doing here tonight is part of service, our call to serve, and indeed making a difference in society. Part of our mission is to fill the information gap. There has been a lot of alarm, excitement, concern, different emotions about the amendment of the Succession Act, and so many experts and consultants have been sharing their views. I would like to thank wholeheartedly my brother Henry, who has taken off time to join us, and of course, more importantly, the Administrator General himself, Acting Counsel Manzi, who on short notice also chipped in to make sure that we have this session. To our dear esteemed clients, especially in the diaspora, I know you have concerns. To our esteemed clients in Uganda, you have concerns too. This and many more discussions are going to help fill the information gap, which, like I said, is part of our core mission. I hope you enjoy the discussion. Please feel free to ask as many questions as possible. We may not exhaust everything tonight, but I want to assure you that we are going to continue pushing the information campaign. We'll have more X spaces, more podcasts. We'll have more discussions, and when you have time, kindly visit our handles. There's going to be a lot of information there. Our website, www.kalikumutima.com, at Kalikumutima Law. All this information will be reported.
Thank you, Mr. Deo, for that brief introduction. To go into the conversation today, for those who are on the space, when a person dies, before any person administers his or her estate, he must apply for letters of administration from court. That's if that person died without leaving a will. When the person died while leaving a valid will, another person must first apply for probate before he administers his or her estate. Now, under Section 30 of the Succession Amendment Act 2022, the grant of probate letters of administration issued by a court of competent jurisdiction, before coming into force of the Act came into force on 31st May 2022. That grant has remained valid for a period of 3 years after coming into force of the Act. So basically, all the grants which were issued before 31st May 2022 are going to expire on 31st May 2025, the 3 years expiring. But before I go deep into question, since we have a person of the Administrator General here, I would first like him to interpret for us this section for our audience, what its implication, and maybe if there are various people who have been misinterpreting the section. When were the 3 years supposed to count? Is it from 31st May 2022 or from the specific date on which letters of administration were issued? I know the officers have been going over and over regarding the interpretation of this section. Maybe read it verbatim for the benefit of our audience so that even Mr. Henry can interpret it for us. The section reads under Section 30 of the Succession Amendment Act. It's a grant of probate or letters of administration issued by a court of competent jurisdiction before the coming into force of the Act shall remain valid for a period of 3 years after coming into force of this Act. Now, the Act came into force on 31st May 2022. So it means the 3 years expiring on 31st May 2025. So, Mr. Henry, your first question is to help us interpret this section for us, its implication, and when the years start to run. Kindly break it down for us. Thank you.
Yes, thank you, Alfred. Before I maybe go full throttle into that question, I wanted to just a brief background how we get to this amendment. And it is very important that sometime in 2005, some women activists through an NGO law advocacy for women sued the Attorney General and the Constitutional Court claiming that some sections of the Succession Act were unconstitutional. So, and the key amongst those sections at the time was Section 27, which was dealing with basically distribution of an estate of a person who dies intestate, or simply somebody who dies without leaving a will. So that section had given percentages. For example, a widow or a surviving spouse would get 15% of the share of a person who died intestate or without leaving a will. So the women activists challenged, among other sections, that provision of the law, that it was discriminatory, and therefore sought for its nullification by the Constitutional Court. And indeed, the Constitutional Court nullified a number of provisions in the Succession Act, and that kick-started a process of amending the Succession Act. Not only those sections that had been a subject in the constitutional petition, but also looking at the Succession Act as a whole to see whether we can reform. Because as you are aware, the Succession Act had not been amended since 1972. Actually, it took the country 50 years to amend the Succession Act. So it is not surprising that the amendment of the Succession Act has elicited public interest, because this is not a law that is often amended. It takes a lot of time. It took 50 years, and now we are having the second amendment that was made in 2022. So I needed to just point out the background, how we came to this amendment. So when the Uganda Law Reform Commission took over the issue of reforming our succession law, they looked now at the broader provisions of the Succession Act. And that is where now we come to specifically the section that we are going to discuss, that is on expiry. Why? Because previously it was not clear how long letters of administration could last. It was not very express in the provision of the law. And as we talk, actually, there are people who have letters of administration issued in 1975 and are still having it 50 years down the road. So Parliament, and it is important to know the spirit behind the amendment and the periods that were given, the 3 years, the 2 years, which I'll unpack briefly. But what was the intention of Parliament in giving those brief periods? Because once we don't understand that, then we may misunderstand the whole purpose of the amendment. So the 2 years and the 3 years seems to be a short period for administration of an estate, but the intention was to awaken a country with administrators who were in slumber, if I may put it so. That you have somebody who has letters of administration for 30 years, 20 years, 40 years, 15, 10, or even 5 years. And the issue is, what are you doing in an estate for half a century? So the 2 years and the 3 years, especially the 3 years, because the 3 years are dealing with grants of letter administration, which are going to expire on the 31st of May 2025, was to awaken an administrator to come to court after expiry and explain why they should give you additional time after spending 30, 40, or 50 years administering an estate. So that was the whole spirit of giving you 3-year grace period if you had a grant of letters of administration issued before 31st May 2022. Now, Alfred, coming now to the interpretation, because it was important for me to give context, is the Parliament provided periods. The first period was 3 years which was given to all letters of administration that were issued before the coming into force of the amendment. Now, the Succession Amendment Act came into force on the 31st of May 2022. So Parliament said any grant of letters of administration or probate that was issued before 31st May 2022, in other words, from the 70s to the 80s to the 90s, 2000s, were given a grace period of 3 years to expire. Then Parliament went ahead and said any grant that would be issued after 31st May 2022, that is now after the amendment coming into force, was given 2 years to expire. The third period was for Administrator General, and it is very important, much as in the discussion that is ongoing, nothing much is being said about the grants issued to the Administrator General, and in their hundreds. In other words, they affect the general public as well. So the third period that Parliament provided was letters of administration or probate issued to the Administrator General now as an administrator of estates. Were given 5 years. The reason for 5 years was because as a statutory body we administer so many, and we needed more time, in other words, to wind up. So they gave us 5 years. So in other words, Administrator General's grants are going to expire 31st May 2027. So it is very important that we use this opportunity towards, because there are so many families out there whose estates are under the administration of the Administrator General. So now, those periods that we have talked about, the one that has caused a lot of public concern is the first one of 3 years for grants that were issued before 31st May 2022. Now, those ones are causing concern because, first of all, they are the majority, there are very many, and the people are in the dark. They are saying, now, what do we do? What is going to happen? Are we going to lose property? Are we going to all that is coming. The Administrator General this morning issued a statement to clarify on some of the social media posts that were circulating, which were causing unnecessary panic, that actually people are going to lose property. That is, there's going to be land grabbing and so on and so forth. So it is not true, because the law provides a remedy. Now, after providing for those periods that we have talked about, Parliament went ahead and said you have a right to apply for extension of those periods. Now, the reason is that if, for example, you had letters of administration issued to you in 1980, these are now 40 years plus down the road, you should go to court and give justification why those letters should be extended after 40 years of your administration. Is there a valid reason why these letters of administration should be extended for a further period? And again, Parliament said, even on extension, you must have the consent of the beneficiaries. Why? During your administration, have you maladministered the estate? Have you administered it to the best, in the best interest of the beneficiaries? So in other words, the beneficiaries can even come and say, no, Alfred was the administrator during these 20 years, he has mismanaged the estate instead. So the 3 years is to test how have you been managing the estate. Have you been managing it to the best of the best interest of the beneficiaries? Yes or no? So those are the periods, Alfred, and I've explained the interpretation. The 2 years are for those after the amendment, and those ones people have been, because some of them have already expired, the 2 year grants, and people have gone to court and extended them. And then for Administrator General, like I said, they are yet to expire in 2027.
Yeah, thank you, Mr. Henry, for that clarification. But just to be clear, let me give you a scenario that I got letters admission on 1st January 2022. So the act came in place came into play on 21st May 2022. So my letters of which I got on 1st January 2022, did they expire on 1st January 2023 because those are the 3 years, or they are also now expiring on 31st May 2022?
Yes, like we said, the grants that are expiring on 31st May 2025 are those grants that were made before 31st May 2022. Okay? So now, a grant of 1st January 2022 is expiring on the 31st because it was made before the amendment of the Succession Act, before the succession became effective on the 31st May 2022. So that one scenario of yours of January 1st, that is before the amendment came into effect. So it is also having 3 years. So it is only grants that were made after 31st May 2022 that were given 2 years. Okay? And actually these days even the courts indicate on the letters of administration the exact expiry date for those that have came after the amendment.
Yes, why I need clarity, there have been court decisions which were saying that even the grants issued before May 2022, the 3 years started to count on when that grant would have been issued. But I think from your clarification, it was a blanket 3 years extension, no matter when the grant was issued.
Yes.
Okay, we need that provision to clarify the public on that regard. So now going to the next question. So now for individuals who are granted letters of administration before May 2022, what were they supposed to do with those grants? What responsibilities did they have to do in managing the estate? Because I think those are things I was supposed to look at when they are going to apply for renewal extension. So what if I received a grant before May 2022, what was I supposed to do? Because I think the same thing was supposed to do when you receive it now. So maybe we could first address that.
Yes, so now that is very important because like I noted, before 31st May 2022, the letters of administration, it was not expressed in the law on their expiry. Only that the letters of administration themselves said that file an inventory within 6 months and accounts within 1 year. Okay? So some people wanted to interpret that to mean that you were supposed to administer an estate within 1 year. Okay? So when you look at all letters of administration before the amendment came into force, the 70s, the 80s, the 90s, the letters themselves said you file an inventory within 6 months and an account within 1 year. Okay? But of course, that is not happen. And case law in the old times said that no, there wasn't any limitation on the period. It depended on the complexity of the estate. Okay? So the case law that we have, Justice Odok in one of the cases before the amendment said that no, an estate can take any period of time depending on the complexity. Okay? Some estate can take 1 year, some estates can take 10 years. It depends on how complex the estate is. So in other words, it was not very clear what is the period, and hence the amendment that made it now very express that it is 2 years. So now, those who got letter of administration before the amendment, what were they supposed to do? succession law is such that when you get letters of administration, you are supposed to distribute the estate to the beneficiaries. That is one. Two, you are supposed to file an inventory within 6 months. And as we talk now, there are so many people with the old letters of administration and they have never filed an inventory. An inventory, what is an inventory? An inventory is just a report to court on what you have found constituting the estate. Who are the beneficiaries? What is the property that was left by the deceased? Have you distributed or not? Is a report. That is within 6 months when you get a letter of administration. Even now, under the amendment. So it applied both. So those people who got letter of administration before amendment were, one, supposed to file an inventory within 6 months, telling court the deceased have established that the deceased had 10 children. I've also established that the deceased had land in Endeavour and Bwaise, and had also some money in the bank or NSSF. In other words, you make a report to court within 6 months. Now, the law is that if you don't make a report, that report within 6 months, one, it is a criminal offense. Of course, many people don't know that. And like we know in Uganda, there are so many criminal offenses which we are not aware of, and even the police is not aware of. So they can't even prosecute you for them. So not filing an inventory is a criminal offense, but also is a ground for revocation of those letters of administration. In other words, if a DIAC is an administrator of an estate and I discover that he has not filed an inventory, I can make an application to court for revocation of the letters on ground that he has not filed an inventory. So now you have to file an inventory, and then after filing an inventory, in the olden times before amendment, you are supposed to file an account within 1 year. But some people within 6 months, when they filed the inventory, they notified the court about the complexities of the estate, and it was important. For example, you can say I've failed to administer an estate because the property I was going to distribute is a subject of a court dispute. So an inventory also gave court reasons why you have not filed, why you have not distributed the estate. So you could give those reasons in that inventory. So when 31st clocks, one of the things people are going to be met with, the old administrators, I will call them so, is that when you are going to now extend the grant that has expired, the first thing court is going to ask any administrator of the 70s, 80s, 90s, 2000s is, one, did you file an inventory? Because they are not going to extend that grant if you have not demonstrated or proved to court that you filed an inventory. Okay? Even the Supreme Court actually has now made it very clear that filing of an inventory is mandatory, and actually that when you don't file an inventory within 6 months, you must apply to court for extension of time. Now there is also extension for an inventory. Okay? We are talking of letter administration, but there is also now an inventory. You have to go to court and provide justification why you should file an inventory 20, 30, 40 years after you had obtained. So those are challenges that people who have all the grants are going to face come 31st when they put in an application to extend. So your question, Mr. Diaka, was what they should do, and that is what I have to submit on that particular.
Yeah, thank you. Now, thank you for answering my question. For those who are on the space to realize, what was first difficult as administration was file the inventory within 6 months, and it's a criminal offense if you don't do it. Many people don't know that. Even me, I think I didn't know very well. And it's a ground for revoking those letters. So, So if you don't file an inventory within 6 months, it's mandatory. If you don't do it, you must apply for extension of time to do so. But I would like to shift the conversation a bit to Mr. Deo before I come back to you. You know, when people apply for it as obligation, it's basically, in most cases, they want to live in the land of the estate of the deceased. And you know, the addition of such estates always intersects with the Succession Act and the Land Act and the RTA. So under the Succession Act, any disposal of estate property which is contrary to the Act is null and void ab initio. So like if I dispose of property of a deceased person without complying with the Succession Act, that disposal would be invalid. So as that means that as an administrator of the estate, there are steps you are supposed to follow to dispose of that land of the estate legally. Now, from your expertise, I'm sure you have practiced for almost 15 years now as a land expert.
More.
Hey, more than that.
Way more.
I don't want to think that you started practicing before I went to school. So as a land expert, talking to an administrator of the estate, what are the proper legal steps required to validly dispose of land from the estate? And then from the buyer's perspective, what should I look out for to avoid being defrauded in a land transaction involving an estate of the deceased person? Because you may find a person who is disposing of the administrator doesn't know what he's supposed to do, and then he sells to me also without knowing what I'm supposed to do, and then I end up having a fraudulent transaction or a transaction which is null and void without the other party knowing whether I was doing right or wrong. So in that regard, I would just like to take us through what a person, an administrator of the deceased must do to validly dispose of the estate of the deceased person or land in an estate. And in that regard, you look at the buyer's perspective, what I must look out for to avoid being defrauded or selling to me here as when I'm buying land from a deceased estate. Thank you, Mr. Deo.
Thank you so much, Alfred. And indeed, maybe I started my practice when he had just started going to school. Anyhow, I'm not going to set my own questions, but allow me first clarify something. Who is an administrator? We need to understand that. An administrator or executor is a legal representative, acts in trust for the estate. Okay? It is very important for the listeners and the viewers to understand this. You act in trust. You owe a duty to the estate, a duty to act in good faith. You're not permanent and pensionable. Okay? We do have family enterprises, I'll not go there at this stage, where certain roles can continue. But the purpose, like Counsel did submit, is that you are given legal capacity to manage the affairs of a state within a certain period, file an inventory, that is after the distribution has been done, within 6 months, render an account. This is accountability. Now, the law has made it clear that within 2 years, this mandate is expected to have been carried out. And if it is not, you can seek an extension. I felt I needed to clarify that. You are a trustee. Now, the Registration of Titles Act, to be precise, Section 118, talks about what an administrator should do as far as property is concerned. And I'm glad you talked about property. You know, I love property, Alfred. One, you have your letters of administration. You have had them certified. The law allows you to be registered as administrator, if it is titled land, to be registered as administrator on the title. An entry is made. And when it is made, from that, it is effective from the last entry. That means if X died 2 years ago, even if you're registered today, as far as proprietorship is concerned, your role is going to run from the last date of entry. So you are entered on the register as administrator. Now, maybe another thing that I need to clarify, we have administrators who double as beneficiaries. We have administrators who are not For example, Kalikumutima Deo, in my capacity as an office of court or as an attorney, I can actually administer an estate. Administrator General does administer what? Estates. Some people allege that you're beneficiaries. That you're having some quiet allocations down there. So you are registered on the title as administrator. For this registration to be done, the practice currently is that the Register of Titles must be satisfied that indeed you are administrator. That indeed you are administrator. So the practice is that they write to the court to confirm whether or not the court did issue this what? Grant. And they now request, and this is because of issues of fraud. The Office of Titles does request for a copy of the petition, a certificate of no objection from Administrator General, just to be sure that indeed X is the administrator. And on top of that, they also go ahead to request for that verification. Now, once that is done, the administrator is entered on the register. We have so many people who are, you said 30, 40 years, they are holding on to titles. It is a magic wand. This is my property now. They are not even registered on the title as administrators. So they must go through that process. And allow me once again re-echo that your role is one of a trustee. You're not permanent and pensionable. Now that answers the first part. Now on the second part of the question, sorry, I'm going to move a bit fast because of time. We need to allow our viewers and listeners to ask questions, and I'm not going to be academic. I want to be as practical as I can be. What should a purchaser do? I know several of our clients, especially our clients in the diaspora, are concerned. The real estate sector contributes substantially to the GDP of Uganda. The diaspora alone contributes over $1 billion to the real estate sector. Yes, we are talking about what? Property. Now, before you go into these substantial investments, what is expected of you? Elaborate due diligence. Elaborate. Do not stop at carrying out a search at the land office. You must investigate the entire process. How we do it at Kalikumutima and Company Advocates, we actually start with the death certificate. Confirm that indeed there was a death. I know some lawyers say, no, but there's a grant. Why do you need to do? No, go to the dot. Yes, someone died, sorry, okay, the death certificate is here. 2, there's a certificate of no objection. How did we arrive at this certificate of no objection? Was there a family meeting? Was there a due process? We interrogate that entire cycle. The entire cycle is provided by law. Did they advertise? Then we go to the petition. These properties that we are talking about, were they declared? Do they actually form part of the estate? Many administrators actually leave out properties. You will allow me at a certain point to talk about discipline. One of the biggest causes of challenges in this country, in my humble opinion, is that we have discipline what? Issues. So you must exhaust the due diligence, go through all those what? Parameters. That is as far as the grant is what? Concerned. And like we said, the role of an administrator is a role of trustee. You're surely not the sole beneficiary. Okay, it depends. We do have certain estates where the administrator is actually the sole what? Beneficiary. So if this estate has an inventory, we are also going to investigate, was the distribution actually done and to who? Is this the beneficiary entitled? If it's going to be a transfer, surely the beneficiaries must what? Consent. In writing, it is very important. That fills in the gaps. I have, for the last 5 years or so, talked about red flags on purchase, and I have been emphasizing the issue of estates. This is why. You need to be extra keen. Now, because of that article that was misinterpreted, people are saying, now, you should not buy estate. No. Just be extra what? Cautious. So, was the distribution done? Okay, that is investigated. 2, is there consent of the beneficiaries? That is also investigated. Now, that is on the part of the estate. Now, on the part of the land generally, we have the other usual basic parameters. Go with the surveyor, open up boundaries, ascertain the acreage, have a land valuer to have the indicative value of the land. So you exhaust the entire due diligence procedure. Because if you do not, you're finished. You're finished. So I'm glad the Administrator General did clarify today. Mr. Manzi did clarify that it is not all doom and gloom. But surely, I emphasize this every time I speak. Land is the only asset that I know that does not depreciate in value. Now you have land on one hand. Then talk about properties generally. If you're going to invest $1 million, put a budget aside to carry out due diligence. Take a cent of water. Don't just throw money in what? In a pit, then come up years after and alarm you say, oh, government is bad, Museveni is bad. I'm not saying that he's good. That is not an issue for debate here. But before you blame government for everything, know that it is a two-way what? Street. You also have a duty. Okay? In as much as you have these rights, you have rights to own property, it is incumbent upon you to make the necessary inquiries. Alfred,
Yes.
are we together?
We are together.
You and I can go on and on.
But we could go on and on, but we don't have such enough time. But maybe to summarize what you have said, especially for that instead of the estate of the deceased, to be a trustee, you are a trustee for that estate. Once you get them, don't sit on the letters. You can have registered on the certificate of letters as the administrator of the estate. For a buyer who wants to buy estate land, do thorough due diligence, investigate the entire estate, investigate certificate of no objection. Most people don't do that. Because usually when person applies for admission and he goes to court and he has certificate of no objection, even court will not investigate how it was issued. But there are scenarios whereby it will be forged. So you can now go back to the general's office to investigate how this certificate of no objection was got. And look at the petition. There are scenarios where a person is selling an estate or land, but the land was not included in the petition. So that one basically means that land is not one who is supposed to be managed by him or her. So you need to also look at the petition to see whether that land was included in the petition, which the person is selling. So that's basically during extra due diligence, as the counsel said, take a cent or whatever. But I know you're burning with fire, but I would like to first go back to the AG briefly. So you see, you gave very many duties, obligations which people, regulators mentioned, are supposed to do once they get them. And then you clarified that according to the Act, these letters are supposed to expire by 31st May. And then you looked at that some estates are complex, you can't administer them within that period. So I'm in this scenario that my letters are supposed to expire on 31st May, and they are going to be invalid by that time. So what remedy is available to this person? So there is a lot of discussion around renewing, extending, validating. So I would like you to clarify what is required, what should be done, and how can I do it, and then the timeline is involved. When can I apply? Shortly after, now, and what grounds should I even be relying on?
Yes. Yes. Thank you very much, Alfred. Yes. Like we had said, letter and session are going to expire. The ones that were issued before the amendment on 31st May 2022, they are going to expire this May 31st, 2025. But like I pointed out, that Parliament knew and provided for a solution within the law. So that's why, as Administrator General, the statement that was released this morning is to allay the fears amongst the general public that people are going to lose property and so on and so forth. That is not true, because the law provides for extension. Now, the law is talking about extension, and of course the debate that has been around is after expiry, can you extend something that has expired, you know? So there was that. It is a very logical argument, but when it comes to letter and session, as we are going to unpack, it is not that straightforward. So because people are used, for example, to leases. When you come to leases, the leases usually talk of two terms. There is extension and then there is renewal. Okay? And the understanding is that maybe something that has expired can be renewed, but it cannot be extended. So the people have given those technical arguments, but as Office of Administrator General, after looking at this law, and we were part of the amendment process, the intention was that even when a grant has expired, it can be extended. And because for it is a unique scenario, and we have made it clear even in the statement of clarification that we issued this morning, that even after 31st, which everybody was fearful of, those grants can be extended even after expiry. And actually courts have done so in some of the cases. Okay? Actually, even in some cases, people who have gone before expiry, courts have said, but that is premature. Okay? Because the idea is that letters of administration, if they have been given 2 years, for example, before they expire, how do you say we want to extend it? Okay? So it is after expiry that court can now say, okay, we gave you 2 years. The reason why we gave you 2 years is that we believe that you should have used that period to complete administration. Now, if you have any justifiable reason, remember it is justifiable, come to court and present the reasons why the letters of administration should be extended, the duration. And we were talking about some cases. For example, let me just give you the scenario. We have seen scenarios where letters of administration have been given 2 years, but court extends it for 7 years. Now look at that. That scenario actually explains to you the rationale of this amendment. If you look at it now critically, the court gives you a grant for 2 years, but upon extension, it extends it for 7 years. Why? Because of what the general public is saying. They are saying court cases, disputes amongst beneficiaries who have lodged caveats on land, and therefore an administrator cannot transfer. Counsel Deo was talking about due diligence. Yes, when you want to buy land, for example, of a deceased person, you go and make a search in the land office and you realize that somebody, Alfred, has lodged a caveat on that piece of land. Of course, that puts you on the alert as a part of due diligence, that you know that there is now an issue here. And the beneficiaries lodge caveats when they are not satisfied with the way administrators are going to they're administering the estate. So now, some of these issues can determine, because the law is not even saying the maximum period that they can extend it. Parliament left it open. So this is just giving us a teaser that the Parliament is awakening you and giving you the 3 years or the 2 years to see why, because some estates are so simple that they shouldn't take even 2 years. So you should come to court and give reasons why there should be an extension. So in answering the question, the issue is the remedy is provided for, and that is the remedy of extension. And court has a lot of power to determine which period they are going to give for the extension. For example, an estate receiving pension. We all know that some estates can receive pension for a period of 15 years. Okay, depending on the calculations that a public service does. So if your father or mother passed on and they're going to receive monthly pension as an estate for 15 years, first of all, the law saved this grant that for it will continue until the pension is exhausted. So in other words, technically, the law is extending the grant for the period of pension. So if you are going to get pension for 7 years, the law is saying that that grant will continue for 47 years for purposes of the pension. And then also the law said letter of administration given to a guardian of minor children or minors. Okay? So the law is saying that the letters of administration will only terminate upon the minor or child attaining majority age, which is 18 years. In other words, a guardian who gets letters of administration on an estate that is having children aged, let's say, 10 years, automatically it means the grant will be in force for 8 years. Okay? Because the children are 10 years, age of majority in Uganda is 18 years. So the grant to a guardian of a 10-year-old will continue for 8 years. So the law has provided for those exceptions. So the only issue that people were talking about, which is not specifically provided for, is the court cases, because people are saying that if we are in court and so on, which to me still has a remedy, because there is what they call, and I think Ugandans are now going to utilize the different types of administration provided for under the law. We have what they call the limited letters of administration. Limited grants means that you are given a grant but limited for a particular purpose. For example, court can give Alfred a grant limited for purposes of a suit that he had instituted. Limited. Now, for it is not even dealing with the distribution of the estate. It is dealing with prosecuting that particular suit. So now court gives you letters of administration. Technically, they call it administration ad litem, which basically means limited for purposes of a particular suit that is in court. So that suit will continue. You apply to court for letters of administration limited for that suit, and they will proceed until the suit is determined by court, regardless of how long it will take. So to me, I think there are sufficient remedies that are provided for extension that we have talked about, to limited grants. Court can make limited grants for certain special purposes, and to me that settles any issues that people may have as to expiry.
Well, thank you so much. Now this one, just to clarify or summary what he has submitted. So when your letter is expiring on 31st May, you still have a remedy, even they have expired, to go and apply for extension. And court will determine to what extent it can extend. It's not limited to how long it can extend. I think that's enough clarity. But now I'm going back to land. Just like how Counsel loves land, I also love land. So imagine this scenario. I bought land from the estate of the deceased person, and the letters, I have not finalized the transaction. So just imagine I bought last week and you are not finalized the transaction. And the letters are supposed to expire in now 10 days time from now. So this person is unwilling to apply for extension after letters have expired. But me, I bought land from him and I want him to apply for extension so that I can finalize my transaction. So what remedy is available to me? How can I go about that? Should I apply for myself? Should I force him to fill the application? Just that scenario, because many people are facing it, and usually since people sell land under an estate, some of them are probably with that nature. You know that matters are going to expire, but it sells to you today, knowing they are going to expire, and then it runs away without even applying for extension so that you can validate your transaction. Yet you have already rejected your own money. So Mr. Deo,
I would first pray for him, you know. And, well, jokes aside, this is unfortunate, but it does happen. I did note that an administrator is a trustee. Okay? Then we also have beneficiaries. Now, if this transaction is complete, okay, money has paid, everything done, and the person takes off and say, I have taken over possession, I'll apply for vesting. Yes, I will apply for vesting to have this property vested in my name, because I will be able to satisfy the what? Grounds. That there was a transaction, it is documented, a payment was made, I'm in possession. I can even do it administratively, I don't have to go to court. There are two options. I can apply to the Commission on Land Registration to have the property vested in my name. Or I can go to court and have the property vested in my name. Okay? It is unfortunate, but it happens. The other scenario would be where, say, no transfer form has been executed. Contracts may be signed off, but maybe part payment has been made. Again, the capacity is that of a trustee. I can take on that administrator, but also the concerned what? Beneficiaries. Please, the test, what we need to note here, we need to understand the role of the administrator and executor. Once you understand that role, it becomes what? Easier. So I can take them on and sue them for specific what? Performance. Because on one hand, you have that administrator, but you also have the beneficiaries. So I'll take them on and sue them for specific performance. The other remedies now swing in naturally. I can go civil, I can go criminal. If it is fraudulent and I can satisfy the ingredients, I can also go criminal. You get what I'm saying? But it is important for our viewers and listeners to understand this role. Once you do, it becomes easier. I have some questions for you, my brother, but I'll keep them for now. But maybe I should just put it out there in the interest of time. How practical is this law? We have appreciated the spirit, but is it practical? Previously, like you said, there were no time limits. And the law had remedies therein. If you're not satisfied with what the administrator is doing, you can have the grant revoked. So now we have put a time limit, but how practical is it? And this is a question that many of our diaspora clients have. 70%, I'm going to give you quick statistics here. About 60 to 70% estates are contentious. And you expect them to be managed in two years. You will tell us how practical that is. Because people are getting concerned. You are affecting the economy. You are affecting what? Businesses. Was it the spirit of the law to frustrate what? Businesses? I don't think so. I will request, I'm sorry to ask, but I will request my brother Henry to help us understand how practical this law is. Because the listener there, the viewer, the Ugandan, whether in the diaspora or local, needs to appreciate this. I thank you.
Yeah, actually, was getting that. Just recall the remedies which I have were all bought land just last week, but the deal is about to expire. If you are in the same scenario like me or another individual like Mr. Isaac, there are remedies for applying vesting orders. Mr. Dewa said, you don't even need to go to court, you just need to apply to court and show that there's a transaction, I bought this an actual agreement, but the administrator is nowhere to be seen. They really invest it into. So now going to Mr. Deo's question, yeah, currently this data has expired. The one which they're issuing as of now, they're expiring after every 2 years. As you noted, they even include the date when they are going to expire. So that brings me to the question, just to add on what Mr. Deo was asking. So what was rationale behind this amendment? You gave us the spirit which maybe we're going to add on, but then you would wonder what the key stakeholders consulted in making these changes, because I believe 2 years in minimum. I will give you an example. Very big cases, maybe like of BMK or what. And then 2 years enough to determine this. Even if it's whereby then you apply for examination, there's very deportation in court. So which key stakeholders were consulted? And then from your perspective, is the 2 years period even sufficient to administer an estate? Not normally. Yeah. So that is it from me. Yeah.
Okay. Thank you very much. I want to just, I know Counsel Deo here and group are good Christians. And the Bible says that a good man leaves an inheritance for his children's children. Not even children, but grandchildren. So inheritance is both a legal and spiritual matter. So the idea of succession is that property should leave the deceased's names or the deceased and go into living people. That is the whole essence of succession, that should leave the deceased and go into the living. And that is what they call the rule against perpetuities, which the Supreme Court affirmed in the Nyakana case, where it says that, you see, you cannot postpone Alfred's inheritance for eternity. Because we have people who come to Office of Administrator General and say, for us, we don't want to have this estate distributed. We want it to just be there. So it remains, you find the person died in 1980, his property is still in his names as we talk. So that offends that rule. They talk about that rule against perpetuity, that you must, property should leave the deceased and go into living persons. And in my view, that helps the economy. Because you see, when the property is still tied up in a deceased person's names, then you have to do the very hard work that Counsel Deo was talking about, because it becomes dicey how to deal with the property of a in a deceased person's names. That is one. Two is practicability of this law. Now, when you need to understand it now from the context that, yes, okay, people were given 50, because I think the first letters of administration started being issued in the 70s when the Succession Act started applying to Ugandans. So we want to know, a person who got letter administration in 1975 and has never completed administration, how much time should we give for an estate? Okay? Because we have given 40 years, 50 years, but still people have not completed administration. And Alfred, you are talking about big estates. Actually, big estates don't even suffer from the issues that we are discussing here. I dare you tell me when you had a dispute on Mulwana's estate. Mulwana is dead. Actually, the bigger estates use concepts that avoid succession disputes. Okay? They use the concept of trusts. Now, that one is not very common in Uganda. It is used by a few, but that is where you find a seamless succession, because somebody actually has created a trust and property is now moving from from a generation to the other. So the Mulwanas will have a generation of property moving. And actually, that is how the Japanese, if we are talking about good economies, the Japanese actually use that concept a lot. That's why you see the Toyota group. Don't think the people who are there are what? Those are now great. Property has moved in families from generation to generation, but using concepts such as the trust. Okay? Because with the trust, for it doesn't die. The people die, but for it remains. Like a company, it is a going concern. So, but that is a discussion for another day, but I just wanted to bring it in that actually big estates don't have these issues. Actually, you realize that actually smaller estates have more problems. Because you'll find a beneficiary saying, over my dead body, you are not going to distribute that land. People have certain attachments, like in Uganda here, certain attachment to certain pieces of land, that even a beneficiary who is in Germany had handled the matter, who was well off, had to fly in, come to Gomba, and swear upon his dead body that land in deep down in Gomba was not going to be distributed. Okay? Put in a air ticket. Now, for him, he's not coming because of greed, but he has a certain succession and inheritance has a spiritual side to it. People become a little bit obsessed when it comes to issues of succession. So that's why Parliament, now I'm coming to the practicability of it. I gave you a very good example that court gives you 2 years, But afterwards, when you apply for extension, it gives you 10. Why? They're saying, let courts look into this matter. Is this an estate that needs really 5 years? No. You have failed on your duty. I think this is not an estate that should take you 5 years. Okay? Then the court can look at it and find out that, oh, this estate actually, yes, 2 years are not enough. We are going to extend it. Given this, that's why you need to give justification. My lord, for example, I was going to distribute this estate in Kololo, but before I could do so, there was a dispute over ownership of that particular piece of land, and we are now in a court in a civil suit number. This A is claiming that particular property. So until court makes a determination as to whether this property belongs to the estate that I'm administering, I cannot distribute it. So I need an extension of time to do that. Now, court, looking at that, in my view, the extension that you will give is longer than, say, an estate where somebody has come and are just saying the beneficiaries are divided on whether to sell the Chibanja in Kaboa or to divide it. And then the court will ask, but how big is this? Okay, even if it is registered land, how big is it? 50 decimals. How many are you? 20. It is impracticable. You cannot divide this. So it has to be sold and everybody gets his share. Some of those, now like that dispute, an administrator can be in that estate for 10 years. Why? These ones want to sell, these ones don't want to sell. Give me mine. But in Kampala, for example, you can't get a title, a certificate of title, for land that is below 50 by 100. Now, that is a practical issue, but some people don't want to hear that. Say, give me mine. Okay? Now, such disputes, court can even dispose of them and order for a sale, and because money can be divided. Even if it is 10 million, it can be divided amongst 100 people. It is easy to divide it. Now, that is going to resolve the practical aspect of it. That if you can't administer within 2 years, come with valid reasons, and court will grant that extension. We have given people 50 years, I'm telling you. They have not. So there isn't as if enough time that the people can be given. But this one puts people on tenterhooks. It puts you are not in a lull that, even if I take 50 years. Now here, administrators are on their toes. In my view, this law has started to work. The administrators are on their toes. You have to administer this estate. You people, if we don't, we need to go and take it. So in a way, people are going to become conscious about time, and certain matters might be resolved which would take us decades.
Thank you. I hope Mr. Deo has been answered. So, and David, who asked on your behalf. So, since you have been answered, I would like to pose the last question to you. But before I get it, I would like to recognize the presence of the Vice President ULS on the space. Thank you, Mr. Asim. Thank you for joining us. I recognize people who have been on the spaces: Seven, Madam Diana, Chibuka. I can't list all of you, but I appreciate even the students who have joined. There's someone who said that he has got another question. They are going to ask him the rule against perpetuities to discuss it. So it's now to discuss it. He has just heard it from Mr. And that is very. This why these questions are here to be informative to that extent for the students, for the clients, for the land investors, and everyone. So thank you for those who have joined us. In case you have questions which you want to ask, we shall be allowing at least 1 or 2 questions. You could either request for the mic to speak, or you could send it in the chat box. We will read it to one of our speakers to answer it. So now, going to Mr. Deo, we can all now agree that there is a lot of fraud in land transactions, especially with dealing with the state of the deceased. And you told me that you have worked for as long, you started working before I was born. So, from your experience of that's like 25 years and more. What reforms, urgent reforms, do you propose can be done to strengthen the integrity of land transactions involving the city estate? And what are there any legal or policy gaps which should believe should be addressed in the current legal framework governing admission of resources and even land ownership generally, so that we try at least to limit this fraud in land transactions? So what are those urgent reforms and what are those legal loopholes or policy gaps which need to be addressed to resolve conflict in land transactions involving assets of the citizen?
Henry is nodding seriously. I don't know whether he wants to take go at it. Now, I emphasize practical.
Yes.
When I asked him that question. In my humble opinion, yes, we do have the laws, but how practical are these laws? That is on the one hand. And this is food for thought too. The bit of implementation. He did joke and he said, people don't even know that they are criminal offenses. So there is an issue of implementation and what? And enforcement. Before we say, okay, there is this gap, yes, implementation is a gap, and it needs to be what? Addressed. Who addresses it? Is it the ordinary Ugandan, or is it my brother here, Henry, or is it the police? We are not going to go into pointing fingers. Then there is also, of course, the issue of selective application of these laws. Tuina abana nebyana. I'm not going to bang tables here tonight. Actually, I know my brother Asimo is there. I don't bang tables. For me, I remove the table. I just take away the problem. It is no longer enough just to bang, bang, bang. You get it? We do have gaps. We need to be more practical. That's why I asked my brother, are these 2 years enough? He has made a compelling argument, and we can go on and on, but I'm partly convinced. Partly. And believe me, we are going to continue what? That discussion. Now, the issue of fraud, we had fraud before Jesus was born. I don't even know whether Ugandan laws are sufficient to what? To address it. But we must make deliberate and intentional steps. And for me, this is one of them. This is one of them, but it needs to be applied carefully. It should not be too punitive. Okay? We have over 8,000 cases at the land division. Family division, I believe, has over 5,000 or about 4,000. So we have now a case backlog. Thank you. I want to thank you wholeheartedly, my brother Henry and the Law Reform Commission, for creating more work for us. Because thanks to you, we are going to have so many more cases, but does that solve the problems? We have over 3 trillion Uganda shillings stuck in these courts. So how practical? What measures can we have in place to address some of these scenarios? I know Law Reform Commission did actually consult stakeholders before they came up with this law. As to whether it was elaborate, that is another issue. And who are the stakeholders? Is it just the Uganda Law Society? Do we go to the lowest cadre, or we don't have the resources, we don't have the logistics? But you see, now it is the ordinary Ugandan who you are applying these laws to. So food for thought going forward in future. As far as the Succession Act is concerned, we are going to continue that discussion. Now, on the part of the Registration of Titles Act, it has actually been, I think there was a recent amendment, the cap changed and everything, but the sections were revised, but I think there is more that needs to be done. I'll give you an example. Section 118 talks about registration of Of an administrator. but it is not exhaustive enough, neither are the regulations. So the Commissioner, Land Registration, has had to be very creative and come up with practice guidelines. That if you're registering your grant, you need to attach the petition. These requirements need to be embedded in the law. They need to be made mandatory if you're saying you're going to fight fraud. Because a guideline is not a law. It's not. I can decide to circumvent I can decide to go around that. Sorry, I think we are hard pressed for time. So we need to allow some questions. Does this also amount to parting shots or not yet? I saw my timekeeper smiling, so let me stop there and we allow some questions. We have two classifications. We have intestate succession and testate succession. Yes, I'm doing it intentionally. With intestate succession, we have an administrator. That means there is no will. You go through the process of administration. After the death, you go to the office of the Administrator General. A family meeting is held. An administrator nominated. There is no objection. You petition court. Court will give a grant to an administrator, and there can be several. Where there are several, they have joint mandate. Then we have an executor or executrix. This arises under testate succession, where we have a will. X has left one or two executors to implement their wishes when they pass on. So in one category you have a will, that is testate. In the other category, you have intestate, you have administrator. I hope that answers the question.
I believe Sarah has got the difference between administrator and the executor, and the roles, they have the same roles. I think I can just clarify on those. That an estate have both. No, the estate can only have only one. That is either the administrator, where there was no will, or the executor, where there was a will. So I think now Mr. Henry would answer this one from Mr. Chiwanuka.
Thank you very much. Just maybe to even supplement on Counsel Deo's on the administrators and executors, there are two, but there's the third scenario, which is like in between the two, where you have what they call letters of administration with a will attached. Now that person is an administrator, but he's also performing a role of an executor. So it is a fusion of the two, and so that makes it three. So now letters of administration with a will attached, meaning that there is a valid will, but that will doesn't appoint an executor, for example. Or it is a valid will appointing executors, but the executors either have died or they are unwilling to apply for probate. It is a very common scenario in practice. So now it would mean that a family meeting now is held, yet there is a valid will. But the purpose of the family meeting is to appoint somebody who is going to implement the will. So in other words, this is an administrator who applied for letters of administration with a will annexed. Then now the suit against administrators, and then they expire. I had hinted about it, and this is what I was saying, that the Succession Act has actually so many remedies which we have not taken advantage of, and I think such scenarios are going to make us actually start using certain remedies within the law. The Succession Act is so big, even as we have been practicing in it, but we still learn new things every day, the Succession Act. So the issue of administrators for purposes of a suit, because the law provides that when, for example, even these people who die when the suit is still, you institute a suit A against B, and B dies before the case is completed. Now, the practical scenario, for example, which for us we engage is the family of that B who has died, naturally, will drag their feet to get administrators. That one, people will attest to it. They will drag their feet because, first of all, it is like you are inviting liability on yourselves. Yes. Yes. So now what they do is they sit back and not do anything. Then the plaintiff, like you had put it, for him, he wants a remedy. Now what happens, the plaintiffs, what happens is that actually tomorrow I'm going to the family division on a matter of this kind. They had gone up to the Supreme Court, but the appellant died. So now the respondent is very desperate. Now the other family is dragging their feet. Now they have applied for Administrator General to be appointed administrator. Yes, to go into the shoes of the deceased. Innovation. Yes, yes, yes. You see? Because the law just says that a party to a suit where one party has died can nominate a person to be an administrator for purposes of that suit. Okay? And one thing that people do is to appoint an administrator general. Okay? So we stand into the shoes of a deceased person while the beneficiaries are sorting themselves out. Okay? So that is one scenario. The other which I've seen is that they sue one of the beneficiaries saying, you come and be part of course that is problematic. The other one doesn't want, but now court makes a decision as to whether this son or heir of the late should come and stand in the shoes of the deceased. Okay? So and he's appointed for purposes of the suit. It means if, for example, now why people fear, they think that if you go into the shoes of the dead person, and let's say the suit is in favor of the plaintiff, they think that you are going to personally pay the costs. No. It is the estate. Even if you take Administrator General, let's say Administrator General goes and stands into the shoes of a defendant. Okay? And then the defendant loses the case. The costs are going to be against the estate. Not a government, for example, or Administrator General. So to me, once we understand that role of an administrator for purposes of the suit, then it becomes much easier.
Maybe to quickly add my voice.
Yes.
That is why I had intentionally, because he did allude to the question earlier. Now, just the two very quickly. The roles of administrator and executor are similar. They are managing estates. Okay, that is on the one part. Now, in regard to the second question, the suit is not going to abate because someone is dead. You have to move court and substitute. Now, on one hand, we have those who refuse to get letters of administration. He has given you the scenario. Then we have others who get letters of administration because they want to deal with the property and they keep quiet. This is where I encourage lawyers to be innovative. Do your searches. Go to these courts, you will find that there is a certain administrator keeping quiet. We have handled 3 matters where the fellow was whistling in the village thinking it was all okay. We got to know, we verified, applied to court, substituted, and proceeded and concluded the matters. So these people are not going to write to you and say, oh, now I have been appointed as administrator. No. You need, as an attorney, you need to be creative. Thank you.
Of your parting shots, but when Mr. Henry was submitting, there was some point he made on estate planning regarding trust, how they use it in Japan, where with big estates where you have a trust instead of now dealing with it as valuation and what. So it brought me to another discussion of estate planning and the If I tell you to have your parting shots, I'm inviting you officially to have a space on the because I realize I know I'm going to be a very rich person. So I don't want to leave my family facing this as administration expiry. Then I could run estate planning and have a trustee, and the thing goes on and on and on and on. Maybe that's even now Indians do one family and what, and they are not in court fighting over the same thing, and probably is not aware about such scenarios. So thank you for accepting my invitation in that regard. I invite you to give your parting shots in 3 minutes.
Yes, thank you, Alfred. I think this has been a very interesting evening, and I must thank Counsel Deo for extending the invitation to the Acting Administrator General, Mr. Manzi Victor, who didn't make it on time, and he gave me the privilege of representing him. Estate planning is the way to go, and I accept the invitation because that, to me, like Counsel Deo was emphasizing, is that we need to be creative. Okay, the other countries, especially the US, when you read about it, they have gone beyond what we are in now, and you plan for the estate while you are still alive. There are so many innovative estate planning tools, as simple as, for example, co-ownership of property. Okay, I know people, for example, who just buy land and put them in the joint names of the children and the wife. Now, that is a powerful estate planning tool that is going to avoid letters of administration or probate. Because if I'm jointly owning my land with my children, 5 children, I die, the land is for the children. The children die first, the land is mine. So really, what is it? Yes, and I don't need to go to court. I don't need to go to court for anything, okay? Because of the principle of survivorship, that when one dies, joint ownership, the property devolves to those who are surviving. It is the automatic operation of the law. Company shares, for example. Having shares in the company, you create a company and then your children have shares in it, and then the company is owning the land. So there is nothing like letters of administration because the company doesn't die. So there are many estate planning tools that we can discuss, and in my view, that will reduce on the strain we are having with this. Okay, it can go a long way. So I want to thank the audience and say that the law is subject to reform. Much as we have this law, it doesn't mean that is the end of it. Through such discussions, like Counsel Deo had said, that practicability, we can say, okay, if 2 years are not, but let's first test. You see, it is important to test a law, then now propose reform. So now we can go through this, and maybe 2-3 years down the road, we are like, wait a moment, I think 2 years is not enough. I think maybe 5 years is. After testing it, because we might also see some positives about it, and in my view, they are there. I've already witnessed some of the positives, that some people are now on tenterhooks. They're like, we need to work on this matter before expiry. Let's agree, you people, let's sell this property and share the money, instead of saying we want to divide 50 by 100 into 10 plots. Okay? So to me, I think it is a law that should be tested, and we are open to any further reforms, provided it is good for the economy and us as a country. Thank you.
Thank you so much, Mr. Henry. So, everyone on the space, be on the lookout. We shall be having the commercial on estate planning in some time to come. So, in the meantime, follow our social media handles. We shall be having that conversation very soon. Just be on the lookout, and once we announce the conversation, please attend as we have attended to that and be part of this discussion. In that regard, I would like to invite Mr. Deo to give us his parting shots in
1 second.
I'll give you 2 minutes.
I need a second.
2 minutes.
Allow me re-echo. We need to understand the role of an administrator, executor. They are trustees. They act on behalf of the estate. They are legal representatives. You're not permanent and pensionable. You have a duty to the estate, a duty to act in good faith. 2, we need to have laws that are practical. 3, and this is to my diaspora family and my Ugandan family, it is not all doom and gloom. Before you go into hot deal of coming to the country, I have only 2 minutes, I need to go, man, I need to go. We must do elaborate due diligence. You're running away from professionals because you don't want to pay legal fees. You're investing billions of dollars and losing them at the same time. Engage professionals, carry out elaborate due diligence. 4, plan for your affairs in your life. You read off my script, my brother. You must plan for your life. Have a will in place. And if you're going to have a will, we live in a digital age, have it recorded. Because many people say, no, it was forged, He talked about, very elaborately, estate planning. Section 176 of the Registration of Titles Act talks about survivorship, where you have proprietors registered jointly. We have the doctrine of survivorship, like he said. One passes away, you move to the next. And the process is simple. Okay, not so simple. It may affect my fees. But you do apply to the Commission on Land Registration. You make your application, attach proof of death that I was registered with X. Unfortunately, he has gone to meet his maker. Here is proof that he has gone. Please remove. You will have continuity. Sustainability is very important. If you want to build legacies, have the joint ownership, have your wills in place. Though the will is not going to help you so much. There's a lot of conflict coming out of that. You have a company. The company is not going to die. Shares are transmitted. You have a trust. I think we need to have another discussion on that. Though you have not invited me, by virtue of the by virtue of the fact, I'm going to take away the table. I don't bang it. By virtue of the fact that I'm the host, I will invite myself. We need to continue this discussion, but Ugandans, local and in the diaspora, do not give up. It's not late. We have remedies. And please look for organized professionals. You need people who are organized. This issue is sensitive. There's a lot of excitement. I'm not going to run an advert for Kalikumutima. No, we no longer have to do that. Not that we have ever done it anyway. We represent diaspora interests in Uganda. We're going to keep doing that. We have so many wonderful law firms. Just make sure they are duly licensed. And they have, for the bigger projects especially, they have their professional indemnity. They will be there for you. I'm not saying that you should do due diligence on lawyers, but I'm sure you get the point. Thank you so much, our viewers and listeners. And thank you, my brother, Henry. It has been wonderful discourse. Alfred, to our director, Howard, the assistant director, Stella, the second assistant director, Isaac, the camera crew, I salute you. We are going to continue doing our part as Kalikumutima and Company Advocates to fill the information void. We're going to continue making a difference in society. It is part of our call to serve. For those who have missed this, I'm sure Alfred is going to talk about this. The recordings will be shared. Committed to serve for God and my country, Kalikumutima Deo. Chief Servant, Kalikumutima and Company Advocates. I thank you.
Yeah. We thank you. We shall be back shortly. The recording will be shared on the space and we shall upload on YouTube as well for those who want to be the visuals, not just the recording. Thank you for joining us. Have a good evening.
Kalikumutima and Company Advocates, translating visions into reality. For more information, visit our website www.kalikumutima.com.